Good evening, everyone. My name is Judge Cecil J. Thomas, and I'm the chair of the James W. Cooper Fellows Education and Program Committee of the Connecticut Bar Foundation. It's my pleasure to welcome you to this evening's discussion, which serves as the launch of the new Connecticut Civil Access to Justice Speaker Series, which is jointly organized by the Connecticut Bar Foundation and the Connecticut Bar Association in collaboration with the Connecticut Judicial Branch. I have the honor of serving as the chair of the organizing committee, and I'm incredibly grateful to all of the members of our small but mighty committee for their support for this new series and for this exciting launch event. This series represents a continuation of a long, ongoing, and far-reaching conversation within Connecticut's legal profession and within society at large about the civil access to justice gap. 60 years ago, Justice Lewis F. Powell, Jr., then president of the American Bar Association, delivered that famous, often repeated quote, that equal justice under law is not merely a caption on the facade of the Supreme Court. It is perhaps the most inspiring ideal of our society. It is fundamental that justice should be the same in substance and availability without regard to economic status. As a legal profession, conversing amongst ourselves, conversing with society, and particularly in our conversations with those most in need of our assistance, we've always kept those inspiring words as a light shining on the horizon, guiding our efforts to uphold the guarantee of equal access to justice. It goes without saying, however, that we continue to experience a civil access to justice gap, sometimes referred to as a crisis. That gap exists between the unmet legal needs of Connecticut's residents, particularly those of limited economic means, and the measures in place to address those needs and to ensure equal justice under the law. Equal access to justice is a foundational commitment of our society, which, like so many other ideals that we hold dear, calls us ever onwards to do more, to evolve, to maintain, to build, and at times to rebuild. Tonight's discussion will help set the stage for that continued conversation through this series by helping us to define civil access to justice and to quantify what it is that we are trying to solve when we speak of the civil access to justice gap or crisis here in Connecticut. We are honored that Chief Justice Raheem Mullins will open this first session with remarks to set us on our journey. He needs no introduction, having been appointed as our Chief Justice in 2024, following many years of service as a Justice of the Connecticut Supreme Court. His appointment followed many years of distinguished service as a jurist in our state's Superior, Appellate, and Supreme Courts, and as an appellate prosecutor and assistant attorney general before his appointment to the bench. Chief Justice Mullins has already demonstrated his deep commitment to equal access to justice through his leadership, his service as a judge, and the initiatives that he has undertaken as Chief Justice. I can think of no better leader to help us launch this new initiative, and it is an honor for all of us to welcome you today. Without further delay, I welcome Chief Justice Raheem Mullins to give us his opening remarks. Mr. Chief Justice, welcome.
Thank you, Judge Thomas. For a second there, I didn't know you were talking about me. I thought you were talking about someone else. It is great to be with you all this evening and to see so many of you present for this evening's webinar. As you can imagine, I'm asked a lot to speak before various groups, and the topics vary greatly. But I can also tell you that tonight's topic, access to civil justice, is at the top of my priority list. So it's an honor to be here, particularly as the inaugural keynote speaker for the Connecticut Civil Access to Justice Speaker Series. Before I get started, there are a few folks and groups I want to thank. First and foremost is the Connecticut Bar Association and the Connecticut Bar Foundation, both of which are jointly sponsoring the Connecticut Civil Access to Justice Speaker Series in collaboration with the Judicial Branch. My understanding is that the Speaker Series will feature virtual presentations throughout the year addressing the civil access to justice gap and potential solutions. To say that I am thrilled about this initiative would be an understatement, and I am grateful to everyone involved in organizing these events. I'm also grateful to my colleague, Judge Cecil Thomas, who is chairing the Speaker Series program. As you know, access to justice has been a longtime passion of Judge Thomas, who made it a priority when he served as president of the CBA from 2021 to 2022. We also have outstanding panelists who will follow my remarks. My colleague, Justice William Bright Jr., Angela Schillinghyde, the executive director of the Connecticut Bar Foundation, David Udell, the executive director and founder of the National Center for Access to Justice, and Deborah Whitkin, executive director of the Connecticut Legal Services Incorporated. I'm confident that this energetic, knowledgeable, and immensely dedicated group will not only provide ideas on how to enhance access to justice, but they will inspire us to act upon those ideas. So the title of tonight's webinar is What Are We Trying to Solve? Defining Connecticut's Civil Access to Justice Gap. Let's start with the first part. What are we trying to solve? Well, what we're trying to address is the actual, and in my opinion, even the perceived issue of unfairness and inequality that infects our system of justice when all people, but especially vulnerable or marginalized groups, don't understand, can't use, or can't benefit from our legal system. Making our justice system accessible to all people is imperative if this pillar of our democracy is going to survive. These concerns regarding accessibility hit especially hard for the people with little to no income who have court matters for which they are unable to retain an attorney. They are tenants being evicted from their homes, in part because they didn't understand they needed to appear in court and ended up in default, or immigrants like an abused immigrant woman with a language barrier who is so afraid of ending up in ICE's custody that she won't seek a very much needed restraining order for her or her children. There's also veterans with PTSD in a court drug program who at the same time may be battling in family court for the custody of his children or her children and don't have the means to hire an attorney. The next question for me then is, why is access to justice, civil justice, so important? Why should we care? Other people manage, why can't they? My response to that is twofold. First, it's simply wrong, in my opinion, to cast aside those who, for numerous reasons, have fallen either on hard times or have never had anything remotely close to a normal living situation, whatever that is. That's my answer reflexively as a human being. My answer as Chief Justice of the Supreme Court and the leader of the Connecticut Judicial Branch is far broader and carries ramifications much greater than one's personal story. Access to justice matters because it's vital to the continued validity, credibility, and effectiveness of our entire system of justice here in Connecticut and across the nation. We are only as good as how we treat the weakest among us, and people's belief in the rule of law depends on how well a job we do with the disadvantaged, disenfranchised, and desperate souls who need legal help to navigate a maze that makes no sense to them. Put another way, if we in power, amid our comfortable lives, a roof over our heads, and ample food on our table, do not help those who can barely survive, then for God's sakes, we have no one to blame but ourselves when people lose public trust and confidence in our court system. That is exactly why we must address this humanitarian crisis facing our courts. And bringing together some of the best and brightest in the room, or in this case, the virtual room, is an excellent way to brainstorm solutions to this stubbornly persistent issue. To assist with the exchange, I'd like to offer some of the areas the Access to Justice Commission is exploring. And Justice Bright, I promise to leave plenty of material for you to cover in detail during the panel discussion. Before I go on, I want to provide a brief history of the Commission as it illustrates how seriously the judicial branch takes civil justice and access to civil justice. In 2011, former Chief Justice Chase Rogers formed the Commission with the goal of increasing access to justice for all people by identifying and removing barriers. And from the get-go, the Commission collaborated with external and internal stakeholders to identify justice gaps and develop meaningful responses to help ensure that the judicial system is accessible. The work the Commission members have achieved over the years is impressive and meaningful, and under Justice Bright's leadership is well positioned to address current challenges. One of the main focuses of the Commission is breaking down barriers for defendants or tenants in summary process matters and providing them with plain language resources to help them navigate the court process. Specifically, the Commission is exploring what resources the court can provide to assist toward this end, including for individuals in our LEP community. In addition, the Commission is discussing a more holistic approach to resolving litigants' court matters when they may not realize the problem they have is a legal one. This approach could be useful when a litigant has competing social issues such as food and or housing insecurity, domestic violence, and others such issues. The Commission also is exploring how to effectively reach people, and one avenue is by bringing court resources into the community through partnerships with community organizations, local public libraries, and social service agencies. Part of this discussion involves defendants, tenants, or otherwise, who have not submitted to the jurisdiction of the courts by filing an appearance. This population is viewed as our most vulnerable, particularly those in summary process. They have filed neither an appearance nor an answer and may be unaware of the consequences of not doing so. Likewise, they may not be aware of the resources available to assist them, including the Right to Counsel program administered by the Connecticut Bar Foundation and the branch's volunteer attorney programs and procedural assistance through our law libraries and court service centers. Commission members are also examining how to increase the number of attorneys performing pro bono work. The Rules Committee of the Superior Court has amended the practice book, Section 2-27A, effective January 1st, 2026, to include language that providing pro bono legal services may be used for MCLE credit for some pro bono work. And while this is absolutely a step in the right direction, the Commission has been actively meeting with representatives from the Connecticut Bar from both large and small firms to get their feedback on how we can better ingrain pro bono work into the fabric of Connecticut's practicing bar. Simultaneously, the Commission is exploring how we can best match pro bono lawyers with clients in need. Some of the feedback that Justice Bright and others have received during a series of listening tours is that lawyers are unsure how to connect with pro bono programs and clients. So as a result, the Commission is seeking ways to make this connection seamless, including exploring a new web interface to simplify the process of connecting pro bono providers with clients. Other important work is also underway. The Commission is reviewing what other states are doing and enlisting the help of justice workers, non-lawyers, and paraprofessionals to assist individuals in navigating the court system. And finally, the Commission has scheduled an Access to Justice conference on November 4th, 2026, to bring together Connecticut's access to justice stakeholders through a series of panel discussions and breakout sessions to explore this important topic further. And yes, Justice Bright, you can count me in among the attendees. If I may just add one other potential suggestion. We want appropriate stakeholders at the table. And I don't just mean the legislature, the governor, court officials, or willing lawyers. I would also suggest going into or continuing to go into those underserved areas and hearing directly from the people who need our services. Intensifying our efforts on the listening tour front to go to our most impoverished areas and become a known presence in those areas. Become a trusted entity to those groups. The more people feel that they are part of the process and part of arriving at solutions, the more success I think we're likely to achieve. I mean, what if we're devoting resources and time towards something that won't ultimately help? And taking this step further, perhaps we should consider including some of those individuals, not only in the ongoing conversations, but maybe as members of some of our committees. My point is that it's one thing for me to imagine facing an eviction, lacking basic necessities, and having no idea of what to do at court, if I even know I needed to go to court in the first place. It's quite another to hear from someone who is every day submerged in the unrelenting uncertainty and cruelty of poverty. We may have the best of intentions on how to deliver a service, but some of our ideas may ultimately be impractical from the point of view of those living the life every day. At the very least, we can gain valuable insight into how best to deliver the services we are offering in conjunction with those who we are seeking to benefit. Clearly, the Commission has a lot of work ahead of head of it, all of us do. The stakes are too high, especially now, to sit back and see how things shake out. And I can assure you that the judicial branch is fully invested in working with you to find and develop solutions. I'm also confident that with so many decent, capable, and committed people involved, our actions will make a huge difference as we seek to narrow the access to civil justice gap. It has been a privilege to address you tonight, and I look forward to hearing from the amazing panel. Thank you.
Thank you, Chief Justice Mullins, for your remarks. Especially appreciated was your focus on those who were affected by the civil access to justice gap and ensuring that we're considering their perspectives as we think about how this conversation and how our efforts will evolve. So again, I couldn't think of anybody better to have us launch this discussion, and we're so incredibly grateful to you for having helped us get started. This is the start of a conversation, and the remainder of our time together will be the panel that will present to you on what are we trying or what are we working to solve to try to set the stage for definitions of the civil access to justice gap. And to guide that conversation and to engage in that conversation, our panelists tonight are all experts in their work, have deep knowledge of the civil access to justice gap or crisis here in Connecticut and beyond, and are really perfectly situated to help us define what it is we're looking at. So our panelists tonight are Justice William Bright Jr., Justice of the Connecticut Supreme Court and Chair of the Connecticut Access to Justice Commission, Angela Schlingheide, the Executive Director of the Connecticut Bar Foundation, David Udell, Founder and Executive Director of the National Center for Access to Justice, Deborah Witkin, Executive Director of Connecticut Legal Services, Connecticut's largest legal aid provider. And to guide our discussion tonight, Attorney Song Kim, Director of Access to Justice and Equity with the Connecticut Bar Association, will serve as moderator. So, Attorney Kim, I'll turn it over to you.
Thank you so much, Judge Thomas. Good evening, everyone. I'm Song Kim, Director of Access to Justice and Equity at the Connecticut Bar Association. And I'm privileged to moderate today's discussion with some of the most knowledgeable experts on civil access to justice here in Connecticut and beyond. So as Judge Thomas mentioned, the goal of our session today is really to ground our conversations going forward with a shared understanding of what we mean when we talk about the civil access to justice gap and what that looks like here in Connecticut. So we'll explore how unmet legal needs really shape the lives of individuals and families, hear about some recent studies that illuminate the scope of the problem, and learn some practical strategies that the Access to Justice Commission is considering. And also place Connecticut in the national context to see what we're doing well and where we still have room to grow. So my first question to each of you, Angela, Justice Bright, Debbie, and David, is how do you define the civil access to justice gap? And what does that gap look like from where you sit, whether in the courts, legal aid, philanthropy, or in national research? Angela, could we start with you?
Yes, thank you so much. And I'm so happy to be here. And I am so thrilled that so many people have registered to attend our event this evening. From where I sit in my seat in philanthropy, um, access to justice is really about the gap um, between people's legal protections that they have on paper and the help they can realistically enforce those rights in the real world. And that gap isn't only about whether or not they can have access to an attorney, which of course is the first thing that we think of and is very important, but it's also about um, how they can access reliable legal information, what barriers are shaped by the complexity of the court processes themselves, language hurdles, digital inequities, transportation challenges, and basically the overall intimidation of navigating a system that was not designed with these individuals in mind. The recent Connecticut Bar Foundation Legal Needs Assessment has really illustrated this very clearly. Nearly 72% of low-income residents, which is over 400 100,000 Connecticut residents in total experienced a civil legal problem in 2024, but many of them reported that they didn't understand their rights or the steps required to address this issue. So, what that means is, although Connecticut's civil legal aid system facilitates access to justice for many, many low income residents, the demand far exceeds the system's current capacity. So, nearly 2 in 5 low income residents who sought legal aid in 2024 were not able to obtain help. And among those low income residents who experienced a civil legal issue but did not seek legal aid, more than 1 in 3 said they were not familiar with legal aid. And roughly 1 in 4 said they did not think that they would qualify for legal aid. And additionally, over 2,000 individuals who called the legal aid hotline in 2024 were unable to access services because they were over income. So, this is where we see the reality of the distance between legal protections and access to the system that enforces those protections. And in another area where we see this is the legal needs that the legal aid system currently isn't being able to support as much as some others. So, although consumer debt, employment, public benefits and healthcare, immigration, and elder law account for nearly half of low income residents' most recent civil legal needs, only though they represent basically only 10% of legal aid cases. More than 4 out of 5 of the legal aid cases currently fall within housing or family matters. And there's really good reasons for that. One, these matters are extremely urgent. They're very widespread, and many of them are specifically funded by programs through the legislature. But it creates a capacity constraint for legal aid and their ability to address other critical issues, which jeopardize directly residents' financial well-being and overall health. So this gap is more pervasive because of how we're funding things currently and what our system can provide capacity for. From where I sit in philanthropy, especially as a funder specifically for legal aid, I try to assess how we can address these gaps. How do we address the fact that demand is dramatically exceeding the capacity of the current system? Our legal aid partners frequently face wait lists, high caseloads, and staffing shortages, which mean many eligible residents can only receive partial help or no help at all. These organizations are extremely capable and they have very competent attorneys, but they don't have the capacity or the resources to meet the need that we are seeing in Connecticut. So, the report that we recently released had suggested several recommendations, which I think, in my opinion, will be able to help us address some of these issues in terms of addressing the capacity issues that our legal aid system is facing. And some of the things that we will be addressing right out of the gate are things like salary parity, retention in the legal aid system. So I don't think it's a secret that our civil legal aid attorneys are not paid at the same rate as even other public service attorneys that work for the state. And because of that, it can be more difficult for legal aid to hire attorneys and retain attorneys to do this work. So, one of the things we will be focusing on that came out of the report is understanding what salary parity looks like and how we can improve hiring and retention for the legal aid community so that we can make sure that we have the best attorneys available and that once they're there, they want to stay and continue and can stay and continue to do this work. Other recommendations included things like expanding service models to look at community justice workers, to look at legal practitioners, or even look at the idea of embedding social workers within legal aid organizations to provide more holistic services, and developing a more centralized, streamlined pro bono system to also support the work of the legal aid organizations. I think focusing on all of these things will help us address these capacity issues so that we can focus on ensuring we are able to help more low-income residents in Connecticut. I also think about the downstream consequences of this problem, this gap, civil legal justice gap. Without early legal help, people experience what in many cases might be preventable crises. So evictions, loss of benefits, consumer debt spiraling into judgment. And philanthropy as a whole ends up funding the emergency response through shelter stays and crisis services, when legal intervention earlier would have been more effective, more humane, and more cost effective overall. So, one of the things that I continue to think about in philanthropy is how do we look at funding our systems to be more preventative and less reactive to the problems? Part of our recent studies included an economic impact report, which showed that legal aid is not just the right thing to fund, but it's also the smart thing to fund. So we know from our report that every dollar invested in legal aid generates nearly $3 in economic benefits. And in 2024, these services returned $10 million in benefits to clients, which generated $12.4 million in economic activity in Connecticut. Additionally, recurring benefits from successful outcomes for veterans and greater educational attainment for children yielded $11.7 million in increased household income over 5 years. And over a 5 year period, $66.8 million in public funding yielded $190.9 million in total economic activity in Connecticut. So, what this report is giving us information on is that there is a greater need for us to be focusing our philanthropic efforts on flexible funding for legal aid so that, again, we can be thinking about these efforts from a more preventative standpoint and less of a reactive standpoint. So, from a funder's perspective, I will just sort of wrap up my initial comments by saying that the civil justice gap is both a challenge and an opportunity for us in the funding sector. The challenge is the scale of the unmet need, but the opportunities are to reimagine a system that can do more by exploring alternative service models and incorporating new technologies and understanding that well-resourced legal aid organizations have the proven ability to stabilize families, prevent homelessness, and strengthen our communities overall.
Thank you, Angela. Justice Bright, could we turn it over to you?
Sure, thank you. First, I want to thank the CBA and the CBF for working to put this program together and collaborating with the judicial branch to focus on these really important issues. From my perspective, just even preparing for this has been incredibly valuable because it allowed me to talk with Angela, who I talked to quite a bit, and Song and Debbie and David about what we're doing well in Connecticut, where our focus should be, and what we can be doing better. I also want to just mention that when you hear the Chief Justice talk about access to justice, he's not just talking about it, he's actually doing it. He came to the national conference this year, took 3 days out of his busy schedule to spend with me and with Angela and Jen Shukla, who I'll talk about in a second, to really dive into a lot of these access to justice issues. It's clearly something that he's committed to, and his support means a lot to all of us who are working in this area. The other tangible evidence of his commitment to this is we hired this fall Jen Shukla to be our program manager for access to justice, a position which we didn't have before. Other states had. I talked with the chief about doing it, and with Chief Court Administrator Judge Bizzuto when she was here, and they were both very supportive. We were happy to bring Jen on. I was a little bit worried because we were stealing her from the CBA, but it was kind of like a win-win because we got Jen and the CBA got Song. So we doubled the resources and commitment to access to justice issues. So I want to thank the Chief Justice for that support, and working with Jen for the last couple months has been a great, and I know she's going to do a great job in helping us move these things forward. So I want to pick up kind of where Angela left off. Angela talked about the preventive efforts. And I do think there are some analogies that can be drawn between the legal system and the medical profession. And the preventative care piece of it is a good analogy, I think. To the extent we can do stuff ahead of time to take people out of the legal system, it is more cost effective and better for the patient or the client. The court system is kind of like, sometimes we're the emergency room, sometimes we're the hospital, but it's not any place anybody really wants to be. If you can avoid it, you want to avoid it. So when I think about the access to justice gap as it immediately impacts the court systems, and I got to change my view here because all I'm seeing right now is the speaker view, which is myself staring back at me, and that's just too much. There we go. That's better. So I want to talk about it from our perspective and people coming into our court, and what do we see and how do we try to help people through the process. And if we put up the first slide, this is the same slide that same kind of facts that Angela started with, and Erica was going to help me with this because I don't trust myself. So these are the stats that Angela started with. 400,000 Connecticut residents experience a civil legal need in 2024, and 2 in 5 who seek the legal aid are unable to get help. Now, not all of those 400,000 plus end up in court immediately, but a large percentage of them do, and a large percentage of them end up in court without lawyers. And as Angela mentioned, this legal system is set up to work with lawyers. No one designed this legal system to say it works just as well when people don't have lawyers. The rules of evidence are really easy to understand, so self-represented parties can navigate that well. You know, pleading, return days, they'll understand all of that. No, we set it up to work with lawyers, and we're now seeing a lot of people without lawyers. So if we go to the next slide. So this was what we saw in 2024. So in housing cases, 62% had at least one self-represented lawyers. Family was 83%. Now, contract collection, debt collection cases, it only shows 23%. And when you look at that number, you say, well, that's not too bad. That means that 77% of the people are represented by lawyers. And even in housing, for years, I've talked about the number being over 90% of defendants are unrepresented. And you look and you say, well, it shows in 2024, it was 62%. We must be making progress. If you go to the next slide, there's an explanation for it and why any idea of progress is illusionary. You look at non-appearing defendant rates, you'll see for housing, there are 62%, but 27% are non-appearing defendants. So we're back up to that 90% number of either people who are self-represented or who are just not even showing up in court. In collection cases, same thing. It's 23% are self-represented, but 67% don't even show up in court. So you have 90% of the cases where we either have a self-represented party or a defendant who doesn't show up, maybe because they don't know they need to show up, they don't understand the process, they can't take time out of their schedule to participate in the process, they don't recognize who the plaintiff is, or they're just scared. They think that going to court means that they're in trouble, and avoidance is an important part of how people make decisions. So we tried to address this in a number of ways as a state, and the next slide will show kind of what we've done on the housing side. We started the Right to Counsel program from 2022 to 2022. It's gone for the last 3 years now, and we've helped over 5,000 households through the program. And when the right to counsel attorneys are involved and can assist in finding rent assistance, about 80% of the clients stay in their home. So that's a great result. And it's a program that's funded by the legislature. It's statewide, but the funding isn't secure. We go to the legislature every year and ask for funding for this program. The legislature has been great about it. We've been in cycles where we've had surpluses. It makes it easier for the legislature to be great about it, but we're not serving as many people as we would like to serve through this program. We would like to get those default rates down to below 10%. We'd like to see the self-represented rates much lower than they are. But it takes money and it takes effort. So we know the right to counsel program will solve a lot of it, but it's not going to solve the entire problem. We're not going to have lawyers for every person in eviction cases. So we have to figure out other ways in which we can help people navigate either eviction cases or collection cases or other cases where they're self-represented. And we try in a lot of ways to do this from a judicial branch standpoint. We go to the next slide. So we have a number of resources where we try to provide information and help to a lot of self-represented clients. Some attorneys also take advantage of some of these resources, but it's largely self-represented clients. So our website had in a 6-month period almost 3 million visits to the website. Now, that's not all people seeking legal help. I go to our judicial branch website to see what our docket looks like and when we're scheduling. So I'm part of that almost $3 million visit or 3 million visits. But there is a lot of information on our website that provides self-help information to litigants to help them understand what an answer is, what they need, what discovery is, what interrogatory is, how you are supposed to respond to that. That information is there. We'll talk a little bit later about whether that's truly effective, but the information and the resources are available on our website. The second is law libraries and self-help. Law libraries, when I was a lawyer, the people who went to law libraries were lawyers. And you would go and you talk to the law librarian who would help you do research. Now, most of our law librarians' time is spent working with self-represented parties and helping them understand the legal resources available and helping them find legal citations and help them with the research. So it's a much different focus. And in a lot of ways, law librarians were trained to work with lawyers. So it's a little bit different for them as well now to become a legal resource for the self-represented parties. But again, over a 6-month period, we had about 19,000 visits to law libraries and self-help desks. The third category is our court service centers and our public information desks. We were one of the first states to have court service centers. And these are lawyers who are, people come in and they have questions and they are kind of the first line of contact for a lot of people about how to navigate the system and how to fill out forms, how to file whatever they need to file. And we, over a 6-month period, had over 21,000 people visit our court service centers. The volunteer attorney programs, which maybe some of the people who are participating today have been part of that program, are programs that we've set up where volunteer attorneys will come in and spend time talking to litigants about the foreclosure process, the debt collection process, just providing them with information, talking to an attorney where there's no attorney-client relationship that's been developed, but they're still trying to help them understand the process and work through it. Legal clinics we run from time to time, and they take on various forms, and there's only over 11,000 people that have visited those legal clinics over the last 6 months. So between May and October. So there's a lot of things that we try to do to make it easier for people to navigate the system. And it's still not enough, as you will hear, that despite all of these efforts, there are still a lot of people who come to court not knowing what they should do, and even as many people who don't even come to court because they don't know either the resources are available or they still don't know how to properly use them. So if we go to the next slide, this just provides similar type information for the period of 2024. The Chief Justice talked about LEP, that's Limited English Proficiency Services. These are services that we provide, whether it's helping people translate in court or translate documents or provide documents and forms in other languages. We do, depending on what part of the state you're in, there's different focuses on different types of languages, but it's an effort where we have been kind of a leader in that area for a long time as well. So we try to do all of these things to make the court process itself. You're at the hospital now. How am I going to get treated? This is what it deals with. This is not the preventative piece that Angela talked about. And I think from a judicial branch standpoint, we would like to see the preventative piece work as much as possible. And now what we're doing from an access to justice standpoint is we are now starting to focus people on, we're trying to focus more on that preventative piece on some of the initiatives the Chief Justice talked about, like community involvement and justice workers and figuring out where the root problem is that is causing people to have to end up in court. We can go to the next slide. One other area I want to talk about in terms of services we provide, and that's mediations. We do a lot of mediations. And the housing number, you'll say, well, it's 91.4% of housing cases, there's a settlement reached. That's true. But I think all of us would concede that in a housing case, the settlement that avoids the eviction at that moment is sometimes just a Band-Aid and not a solution. And, Debbie, you can comment on that when you're talking if you want, but in a lot of times the defendant is in court facing immediate eviction and they will agree to whatever they need to agree to stay in the house or the apartment for another month, another 2 months, knowing that, I'll deal with it later, but right now I have to stay in. And then, so we get a settlement that's reached, but whether that settlement actually ends up solving the problem is a whole different question. And again, dealing with it from a holistic standpoint, from an eviction diversion program standpoint, which Judge Thomas is working on right now, would make a big difference than just getting people to agree to something to avoid the immediate crisis that they're facing. Small claims, it's a similar type thing. I mean, people who go into small claims court and they may reach a settlement with every intention that, yeah, I'm going to pay the money, but being completely unrealistic about whether the settlement they're reaching is actually going to work or whether it's just putting off the day of reckoning. So again, if our efforts are how to deal with it in a more holistic standpoint, so before the person even has to come to court or realizes that they have the problem before they get served, would help eliminate the immediate crisis as well as the longer term issue. The last thing I want to discuss on the last slide is what the branch has done from a financial standpoint, because we realize the importance of legal aid. Over the last at least 10 years, I think probably going back to 2008, 2009, actually, when interest rates went down, really cratered, and IOLTA, which was the primary funder for legal aid, kind of fell apart. The judicial branch stepped in and we created our two fees-funded programs to fund legal aid. And in 2024, the court's fees and grant program provided $12 million to legal aid, and then the judicial branch grant and aid program, which was an older program, provided about $1.3 million. And you can see that IOLTA provided about $6 million as compared to 2015 when it was $11 $1.5 million. So the legal funding, and the other thing that I'm kind of proud about is the Client Security Fund, which we all contribute $75 a year to the Client Security Fund to reimburse clients who have faced defalcation by their attorney. Actually has a bit of a surplus because the defalcation problem in Connecticut isn't as bad, I guess, as it might be otherwise. So we take money from that fund each of the last several years and have moved it over to legal aid and the Connecticut Bar Foundation to help fund the provision of services. So that at this point, I think the judicial branch is the primary funder for legal aid, at least in putting aside private philanthropy. And we think it's important, and I know that Chief Justice is committed to continuing those programs, even though, as we will talk about, it's a two-edged sword when we're talking about using fees and whether fees create a barrier to access to justice. So, it's balancing those issues, and I'm looking forward to talking more about it. So, thank you.
Thank you, Erica, and thank you, Justice Bright. Debbie, would love to turn it over to you next.
Thank you. So first, Justice Bright, yes, wholeheartedly agree that often clients feel pressured to take a deal, knowing that it might not be something that's really workable, but the alternative is being out on the street. So appreciated your comments about that. And also, huge thank you to the Judicial Department for all the support that you give legal aid, as was shown in the last slide that you had. You're a great partner to work with, and we appreciate it. Could we put up slide 1, please? I want to talk about what we mean when we talk about the civil legal aid network in Connecticut. You're hearing that term legal aid over and over, but what do we mean when we talk about that? And as you can see from the chart, it's more inclusive than just the legal aid programs themselves. So we have the judicial branch, law schools, and the CBA, each playing an important role, as do private attorneys and law firms. It's really everything from law school clinics to pro bono projects and individual cases to online pamphlets and the court support service centers that you've heard about. If we look at the second to last row at the bottom of the chart, that's where we see 7 legal aid programs. And each of these small programs focuses on either a particular subset of Connecticut's low-income population or on a particular substantive area of law. And all of these programs serve low-income clients. I'm just going to run through them very briefly. The Center for Children's Advocacy works with children involved in juvenile justice, education, child welfare, healthcare, and court systems. The Children's Law Center provides representation to children in complex family court cases. Connecticut Fair Housing mainly represents clients facing discrimination or foreclosure. And the Connecticut Legal Rights Project focuses on representing individuals with mental health conditions on matters related to their treatment, recovery, and civil rights. Connecticut Veterans Legal Center focuses on overcoming legal barriers to housing, healthcare, income, and recovery. Lawyers for Children America uses pro bono lawyers to represent children who are victims of abuse, abandonment, and neglect. And Open Communities Alliance works to create housing opportunities in historically exclusionary communities. And I know that sounds like a lot of agencies and sounds like a lot of people, but really in total, the number of attorneys is probably less than 20. And then on the last line, we have the 3 full-service legal aid organizations, as well as the hotline for brief advice and referrals. So Connecticut Legal Services is my agency, and as Judge Thomas noted, it's the largest nonprofit law firm in the state. So our service area includes 58% of Connecticut's poverty population, living in 122 cities and towns. It's virtually everywhere that isn't Greater Hartford or Greater New Haven, each of which is covered by one of our sibling agencies. We have a staff of 70, including approximately 49 attorneys, 6 full-service offices, and an admin office that also serves as a satellite office for clients in Middlesex County. Greater Hartford Legal Aid has approximately 31 attorneys, and the New Haven Legal Assistance Association has approximately 22 attorneys. So the 102 attorneys in our 3 full-service programs provide a full range of advocacy, from brief advice to full representation, as well as policy advocacy. And I'm going to talk more about that in a few minutes. And then we have statewide legal services, which is the legal aid advice and referral hotline. And they provide brief services and refer cases to the other legal aid programs and to pro bono attorneys as appropriate. Talk more about them in a minute as well. Slide 2, please. So these are our clients in very general terms. They're people of very low income with critical legal needs, and often a multitude of other problems that are exacerbated by being very low income. For most of our services, to give you a sense of the income level we're talking about, a family of 4 would need to have no more than approximately $40,000 a year in income to be eligible. And our clients often experience one or more of the circumstances listed here. They're coping with their situation as best they can. Maybe they're survivors of household violence. Maybe they don't speak English. Maybe they're being discriminated. Again, any number of these, and then a crisis happens. The next slide, please. So often a client will present with one of these problems. But when we do an initial intake, we discover that they're actually experiencing a multitude of these problems. And they don't know that in many cases there are legal solutions. They don't know, for example, that their Medicaid card confers certain legal rights regarding their medical care, or that their landlord can't just throw their belongings into the street, or that if their child is expelled from school, they actually have a right to a hearing. They don't know their rights regarding many of these situations, and really, why would they? They're not attorneys, they can't afford to hire an attorney, and they've been busy trying to keep their families housed and food on the table. So I want to tell you the story of Jim, as he illustrates some of these above issues. CLS represented Jim in an appeal from a denial of an SSI application, which is Social Security for people who are disabled, basically, which was related to his condition after a serious accident. The accident necessitated surgery. The surgery resulted in a lengthy and severe infection, which left Jim in significant pain and unable to walk, with a very weakened knee. Because he couldn't walk, he lost his job. Because he lost his job, he became homeless, eventually sleeping in friends' cars. He was afraid to have corrective surgery to repair the knee and reduce his pain because he had nowhere to recover and no one to take care of him. CLS represented him in his SSI appeal because his initial application was denied, and we ultimately won eligibility both for future and retroactive benefits. And those funds, together with what will be the new SSI payments going forward, are helping Jim to afford a stable living situation, which will give him the ability to take the next steps toward a full recovery and eventually to return to work, which is his goal. And we often see elderly clients experience a similar domino effect. They're barely making their rent, food, and medical costs when suddenly they're illegally harassed by debt collectors. Do they pay the debt, which sometimes we discover was never really, theirs to begin with? Or do they pay their rent, or buy food, or continue to get the prescriptions? Next slide, please. So legal services makes a difference. We can categorize our impact in general terms in the 3 ways shown here. 1, an overarching access to justice, which provides a sense of basic fairness. 2, individual impact. And 3, social justice, which often is accomplished through legislative or administrative advocacy or class actions that result in a change of policy. And we offer the full range of advocacy that you see listed here. Within our priority substantive work areas, housing issues are what we see most often, followed by family law, and then consumer issues, particularly for the elderly. And of course, these days our immigration clientele list is growing at a rapid pace. Next slide, please. And you can see the variety of work we do illustrated in these samples. We start with 2 civil Gideon projects, and we all were very excited when the legislature recognized the need for attorneys in eviction and domestic violence cases. But as Justice Bright discussed, while these projects increased representation, they really aren't true right to counsel projects because we simply don't have enough legal aid attorneys to represent all eligible clients who are being evicted or whose housing subsidy is threatened or who are victims of abuse. Our services are, however, often life-saving for those we do represent. And I would love to go into greater detail with anyone who wants more information on any of the projects listed here, but in the interest of keeping to my allotted 10 minutes, I'll just touch briefly on 2 of these. The Pardons Project is with McCarter in English, and it has grown from a few of their attorneys attending our clinic to them taking ownership of the project, and we now refer clients to them. And also the Medical Legal Partnership is with Hartford Healthcare and St. Vincent's Hospital in Bridgeport. And that's a new program for us, and we're pretty excited about it. We also do policy and systems reform work, as illustrated in the non-emergency medical transportation case we filed, listed under sample projects. It's also known as the NEMT case for non-emergency medical transportation. And in that case, a team of lawyers, after years of negotiation, reached a settlement agreement in the proposed class action that we filed on behalf of Connecticut Medicaid recipients using NEMT services. So the Department of Social Services and the transportation company were defendants in the action, and the case stemmed from an individual client who was in a wheelchair and who relied on NEMT for his doctor visits. He was left stranded so many times, his doctor actually refused to make new appointments for him, leaving him without medical care. Our investigation showed that the NEMT abuses were widespread across the state, and the settlement ensured oversight and adherence to the NEMT rules and regulations, ensuring that no more patients would be left stranded on street corners. Next slide, please. So here we see the great need for legal aid as expressed in statistics that represent the numbers of low-income residents experiencing various civil legal needs. And some of these Angela talked about as well, but I think it's staggering that over 400,000 potential clients exist and only 102 attorneys are available to provide full legal services in these areas. At CLS alone, we receive approximately 16,000 requests for services each year from eligible people, and we have the capacity to help only about 1/4 of them. Next slide, please. As I said earlier, it's not just the legal aid programs that make up the legal aid network, and Justice Bright talked about some of this. We can see what an impact the court support services have as well. And I think I talked pretty quickly, and that pretty much covers a brief picture of Connecticut's legal aid network and the clients we serve. So Song, back to you.
Thank you so much, Debbie. I know that was a big task that we gave you to give that very brief overview, but that was wonderful. Thank you so much. David, we've heard a lot about the context here in Connecticut. Would you be able to round us out now with some national context?
Well, let's find out. So I have to say, I feel that as dropping in from outer space as I do into Connecticut's access to justice community, I have to say that I find these incredibly impressive people and presentations. And while the need in the community is overwhelming, I do feel that you have, really focused people and focused energy. And I'm also heartened to see 144 people turn out for this event. I understand it's a CLE event, but it's a CLE event on access to justice, and it's wonderful to see that there's so many people here. I'm going to start out with a few slides. I'm pleased to see we're also pretty much on time. And let me just see if I can effectively share my screen. So I'm going to slip through the first few of these slides pretty quickly because the material's been covered very well. And then I'm going to bring us out to more of a national perspective and talk about our work on researching policies in all the 50 states and presenting our findings in something called the Justice Index, which I encourage all of you who are attending today to be familiar with. I like to start with this slide. And there's a human rights movement out there. There's an government accountability movement and transparency movements. There's a legal empowerment movement, and all of these different movements exist alongside the access to justice movement. And I like this quote: demystifying the law means enabling people to understand, use, and shape the law. And all of the work you've described comes within this, I would say, broad banner that people should have some agency over their lives, and that includes working with the law. And we live in what an Amherst College professor called a law-thick society. Wherever you go, almost whatever you do, the law is implicated. And you've heard a much more granular presentation on these things from the previous speakers. I'll just point out that homes, family, debt, food, work, school. I didn't focus on immigration, which I think of as outside, in some respects, the state practice, although it also has implications for what happens in the state courts. But these areas are the big, broad areas that we're talking about. And people refer to the housing courts, family courts, and debt collection courts as almost lawyerless courts. And also they're referred to as high volume courts because the people who are pulled into these proceedings, usually as defendants, rarely have lawyers. And that's not to diminish the work of the legal aid bar, which I'll talk more about in a minute. Now, people seek help all the time, and not all of it is what's down here at number 4. And I think that when lawyers, I don't know who's visiting the CLE today from the private bar or from the legal services bar, but there's a tendency, or from the public, there's a tendency to think that it's all trials and motions and arguments, appeals, things that we think you really have to have a lawyer for. But I want to tee up a discussion later on about what lawyers do and what other people can help people with legal needs do. And so often the questions present themselves in terms of, what should I know about my rights? What should I say about the law to employers, landlords, family members? How can I complete a form that's provided by the courts often, and often intended for use by lay people, but many people are not able to complete those forms. So I want to hold some of those thoughts in mind, and we'll come back to them. Now, there have been a lot of definitions of access to justice already mentioned kind of in passing in this call, in this event this evening, but I want to flag these 5 cornerstones. If you can have 5 cornerstones, maybe you only can have 4, but everyone, and the hint at the top is key. Some people have a lot of it. Some people have none of it. And so we maintain here that everyone should be able to understand their rights, assert their rights, and that's where you would include the provision of lawyers or other helpers or other technologies. Also in understanding your rights, know your rights trainings and public information events, pamphlets that explain what people's rights are on increasingly online websites. But understand your rights, be able to assert your rights, that it occur under the rule of law, meaning that the laws and practices, the policies, if you will, are fair, that they're public, and that they're stable. They're not changing overnight, as happens in some countries, and they're not secret. And most importantly, for tonight's conversation that I'll get to further on in a minute, that we have laws that are fair. And the laws are changing all the time. They're stable enough to be a democracy with, I would say rule of law, but they're always changing in the context of, what is debt collection law, or, what happens in the traffic court, or even the laws governing procedures in the court, which include judicial rules. And so understand your rights, assert your rights. I keep losing my cursor. Under the rule of law in a neutral and non-discriminatory process. That means that there isn't a person making the decision who's biased against you personally, and they're not biased against you as a class. For example, if you are a person of a certain race, or if you're a person with a certain disability, that you can count on the decision maker in the process being neutral. And then at the end of the day, you can expect to obtain and enforce the fair outcome in your case. And these things are all valuable because they let us think about policies and also empirical evaluation through research. Are people able to understand their rights? What are the laws that assure that people can find out about proceedings and get notice? Are people able to assert their rights? What are the laws that establish I know right to counsel as a concept is a debated term, but that are going to authorize the provision of money to fund lawyers so people can assert their rights. And are we going to authorize other people who aren't lawyers to provide that kind of help? And then the rule of law, what's fair? And I already hinted at that, and we'll talk more in a minute. And also, is the process neutral? And do people get their fair outcomes? So Debbie and others, Angela and the justice have talked about the barriers, and I'll just flag them, some of them here. The system is designed to have counsel, at least in the more complex proceedings, and often people lack knowledge. They also lack money. This idea of my problems are my fate, I didn't realize that they had a legal dimension, is very profound and has been demonstrated to be why many, many people don't show up in court. There are language limitations, there are disability limitations. The fairness of these different kinds of concepts that are embedded in law is something we'll talk more about in a minute. But is the law fair? How far away is the court? Can a person even get to it? And then fear, and the justice spoke about this, that people are afraid of courts, they're afraid of bureaucracy, but also they're often threatened with retaliation. They can be discriminated against in their employment settings if they exercise their rights and so forth. So these are, I guess, 7, and there are more, but that's a sort of top 7. Now I want to go to talk about the Justice Index, which is, I think, part of why I'm invited here today. The Justice Index is an online resource, and it collects laws from around the country. And for each state, it ranks the state on a bunch of different categories of law. And it's not based on survey information. It's based on actually what are the laws and practices in those states. And so what is the state doing to assure that people have access to lawyers? And that would include right to counsel. What is it doing to assure that people who are self-represented or unrepresented are benefited by the policies that are in place governing the courts? So that's things like uses of certain technology, court forms. Judges should be instructed that they can be proactive in helping alert people to what the issues are in their cases. And judges can do that without being biased in favor of one side or the other. Language access, long a relatively neglected area in many states. So we rank the states on what are they doing to assure quality of interpreting, for example. And in here, disability access, same with sign language interpreting and access for service animals. Fines and fees is what I like to call a policy scourge, where across the court, partly because the indigent offender bar and the civil legal aid bar were not always in the traffic courts or the municipal courts, for example, fines and fees has become, and partly just state governments and municipal governments looking to raise money from people that pass through the courts. There's been an effort to raise funds for the states and municipalities by imposing fees on them when they appear in court, including in traffic courts. And then consumer, and of course, there's a dual edge to that. And the justice spoke earlier about some communities are partly reliant on those revenues, and weaning yourself off of those revenues as a state government, municipal government, or judiciary is very difficult, but important. Consumer debt litigation, litigation between private parties trying to collect debt, which includes all kinds of debt from predatory lending to medical to student and credit card debt broadly, is another area where policy really matters. And so the index shows that the laws and practices that enable people to rely on the legal system are present or absent across the country in each state. And the idea is that all of us, you on this call, and also the panelists, have an opportunity to promote reform in your respective sectors and communities. And the first question is always, what's the policy next door? What is New York or Vermont or New Jersey? What are they doing on the same kinds of issues that are confronting people needing access to justice in Connecticut? And then there's a ranking system based on points earned, depending on how many policies were found to be in place. And the whole idea is to create incentives for adoption of the best policies. So I think without more ado, there's a lot that I could tell you about how we created the thing. And then I'll turn and talk a little bit about the moment we're in. But if I can take a few more minutes, I'm going to get out of this share and go into another share. How am I doing so far? Kim, everybody's nodding. Continue. Okay, when I have to stop, nod in the other direction. So this is the website for my organization. I hope it's large enough for you to see. And we're the National Center for Access to Justice. And for those of you who are interested in the field and want to learn more, I encourage you to click on this whole area, which I don't want to do and lose the screen potentially, but it's an essay on a definition of access to justice with those 5 elements that I walked you through earlier. So I'm not going to click on that now, but I encourage you to go to it. And on the Justice Index, you can see that we have these menu options, and you can reach it up here. You can also reach it here and further down on our website. But just to speed things along, I'll say that we have a composite collection, a total ranking. And you'll see Connecticut does very well relative to other states, but very poorly when you consider what it would mean to get positive answers on all the policies that we have asked about. And so we'll go there in a second. The other category is attorney access. We have done a civil legal aid attorney count across the country. The last time the ABA did it, we sort of turned it over to them and worked with them to develop their protocol for it. And they have in their Justice Deserts website their most current findings, which are not incorporated in here. We have a consumer debt litigation index, a disability index, fines and fees, language access, and self-representation. And here you can see how governments, courts, and others have been using our findings. And there's a general welcome, which I'll skip because I've been talking about it. But you can see Connecticut up here, not bad, but a score of 62, not that good. And again, you can get into the particular indexes here. If you click on any state, including Connecticut, you'll see more information about how the state did relative to other states and also how it did within the particular traditional 4 indexes. There are more now that have come online that are not visible here in consumer debt and fines and fees, which I think took Connecticut's numbers down a little bit. There are these background essays. I want to switch quickly and go into our most recent work product is the Consumer Debt Litigation Index. Connecticut's further down on this one with a 26. And I guess before I say too much, I want to say start talking about specific policies, but I just want to say that I'm not some guy it might seem this way, but I don't want to be the guy who came in from out of state and said, you have to do these things. It is true that if you want more points in our scheme, you have to do these things. But all politics is local, and it's very local. And so folks who are the other presenters today know far better than I do what Connecticut needs to do and wants to do. And the way that a system like this works, it's not an encyclopedia of all policies. It's some policies, and some policies that in consulting with our experts and an advisory group, we learned were considered favored policies. But states can do well by doing other things. And of course, they can do very well in the index by doing the things that we rank. And in benchmarks, weights, and trends, this is the set of things that we search for in consumer debt. So does the state permit the filing of an answer in consumer debt lawsuits without charging a fee? This is how many points we gave it. And that's the number of states that no longer charge a fee. And if you click on this little yes button, which I hope you'll get to using, you can see which policies were popular and which were less popular. Now, it's a lot of words and a lot of information, so I apologize for being overwhelming, but I've teed it all up to come here and then down here too at the bottom. So at the bottom, if you really want to know about Connecticut, you can click and get an individualized report just about Connecticut. And I want to thank Jen Shukla and others for helping me update some of our data. The consumer debt data was most recently revised in 2024. Connecticut's made some changes there, but it's also made changes across the Justice Index since the other data was updated. And we also don't claim to be perfect. But I want to show you quickly how this works. And then I think I'll stop talking on my share of this portion of the time, but hopefully be able to talk more later. So if you go down to benchmarks by state, first of all, for research people, anybody that wants a spreadsheet with everything, it's right here on every page. But if you go here, you can click on a benchmark, like does the government send out notice of lawsuits? There's a problem with what we call sewer service, where people start lawsuits to collect debt from individuals, but they never serve the papers on the person. They throw them into the sewer, and it's called sewer service. And so the idea that the court would step up and itself take responsibility for serving people a copy of the papers is a big change. In Connecticut, Jen has informed me and showed me, has made that change and relies on certain people as public officials who are responsible for service. Guiding people to legal services offices, we looked for statewide guidance that's required of the court. So Connecticut didn't get credit there. What I want to show you is I don't want to stop on Connecticut on every step, but you can definitely look there yourself. But I do want to show you that there are patterns to these benchmark policies. So if you want to know whether the judiciary has created a simplified opportunity to answer, you click there and you see which states have done that and which states have not. If you want to know whether some states still require an answer in a debt collection case to be notarized, you click on that benchmark and you see that there were 3 that still were requiring that you couldn't file an answer until you notarized the answer. This is no fee to answer, and you can see a pattern across the Northeast and then through the Midwest. Some of the South states still require a fee, and then this whole border on the West and the North still requiring a fee to answer. And so we have a bunch of these. It's actually a huge volume of findings about policies in every state. And you can walk through all of them. So I think I'll stop there and then maybe come back later, because I know everybody has a lot to say and we have questions to get to. I hope that made sense.
Thank you. Thank you, David. Thank you, David, and everyone else for this very informative overview and for all of your perspectives that looked at a range of solutions, from very tactical solutions like legal aid salary parity to resources to support self-represented parties, policy advocacy stemming from the experiences of clients, innovative means of service to parties being sued, and for all of the work that each of you does from your respective spheres to make sure that we are listening and understanding and measuring where the gaps are and where the progress has been. So I have a few questions to go a little bit deeper into the themes that came up in your presentation so far. And it would be great to get your perspectives on them. And we will save a few minutes at the end for any questions from the audience. So for audience members, please go ahead and write your questions into the chat. So my first question, we've heard that Connecticut is a leading state in access to justice in the country, and that we have relatively strong policies on paper, although sometimes there is a lack of implementation. Justice Bright, you've already started touching on this a little bit when you shared about the right to counsel program in eviction cases and how that's faced challenges because of lack of funding. So if you could expand on that a little bit, what causes the gaps between policy and practice, and how do we work towards closing them?
Sure. Before I do that, I just want to say that I find the Justice Index is something that I look at often, and I have for years. And I always took pride of where we were at the top. I didn't realize that we were the best of the worst, or among the best of the worst. But it reminds me, when I was in law school, an 80 was an A. So I'm looking at a 62 and thinking that's maybe like a C. So no. And David said, do you want me to, soften the blow? And I said, no, we need to know what we do well and what we could be doing better. And I'm not afraid of knowing where we fall short, nor should any of us be afraid of that. We should view that as an opportunity to do better and where we should be focusing our efforts. So I thank David and everybody in his group that works on the Justice Index. So where do we fall short? I think that there are a number of we focus, as I mentioned earlier, on how do we make the experience better for people when they get to court. So what we don't focus as well on is how do we get people to know that they have to come to court or make it easier for them to get to court. We're not a big state, so it's not like we have these large geographic legal deserts without a lot of lawyers, or that people have to drive that far to get to from their home to a courthouse. But there are areas where that's an issue, whether that's in the northwest part of the state or the northeast part of the state, or even if you're in Fairfield County and have to deal with the amount of traffic there and not a great public transportation system, it can be a challenge for anybody to get to the courthouse. And we put together all these materials that we have on our website, but there are two problems that I think we haven't really focused on. One is how do people know that that material is there? We have not done a good job of publicizing what's available and how people access it. And with Jen being hired, I'm hoping that we put more of an effort into that and we do a better job of explaining to people what resources are available. But second, this goes back to something the Chief Justice said. We get together as a group of people who are inside the system. We kind of have our own ideas about what works, but we haven't reached out to the communities that we're trying to serve with these efforts to say, do these ideas, do these materials really help you? And until we do that, I don't know that we will have truly effective policies, whether that's on when we hold court, where we hold court, what information we provide to people, what processes they have to do to answer complaints. All of that needs to be tested with the people who we're trying to serve. And that's something that we're focusing on. We have talked about adding non-legal members to our Access to Justice Commission, people from communities, and we're conversations with different people to identify people who can do that and contribute and tell us what's a good idea, what's a bad idea, or what's a good idea but needs to be filled out. The last thing I'll touch on, and this goes back to the Access to Justice Conference, National Conference of 2024. There was a debt collection seminar. And I had been the chief administrative judge for civil. I had, as a Superior Court judge, covered the debt collection docket and was frustrated by the high default rates and how third-party debt collectors would come into court with less than robust information about the debt that they were trying to collect that they had purchased for pennies on the dollar. So I wanted to go to this program. And David was there and they did the presentation. And part of the presentation, they said, in some states have really good policies, but their judges aren't following the policies. And I thought we did have really good policies in terms of the proof that debt collectors were required to submit and what they were required to plead. So I went up to talk to David afterwards and I said, so, have you guys looked at Connecticut? He said, yeah, you're the state I was talking about that we did the study on, that you guys have really good policies, but your judges don't follow them. Now, the study was on small claims court, and we were talking about the study focused on our small claims magistrates. So it made me think, all right, so what's the problem here? And I think we have to take responsibility for that, whether it's a training issue that we have to do better training, or whether it's a press of business issue. It's really kind of human nature for anybody who has a large amount of work in front of them to say, okay, how do I get through this work? And the other side didn't even bother showing up. So I'm going to just accept what the plaintiff who did show up told me, because I have no reason to doubt them. Well, if you've seen any of these presentations, there's often reason to doubt them. So I think we need to do a better job from the judicial branch standpoint to making sure the policies we put in place are actually getting implemented, whether that's by court staff or by the judges who are sitting, and that's a training, that's a kind of an auditing process afterwards to make sure that's happening. But implementation is as important as developing the policies, and that's I think what we need to focus more on.
David, I think you might be muted. There you go.
So sorry. Trying to be better with my mute button. Well, so first of all, Justice Bright, thank you for your remarks at the beginning about understanding that where Connecticut doesn't do well on evaluation, what you get is an agenda for change. And when I work with around the country, and I see lots of courts, including the Court of New York, and I'll just say that that's not the universally held view. You know, I would say there are a lot of judges that embrace adverse findings and see the potential and power of it, but some are more defensive. And it's really a tribute to the leadership here in Connecticut that since we started this project almost 10 years ago, that has always been the response. Like, what can we do? How can we make things better? And many things have changed in Connecticut. So more power to you, and you know, my utmost respect again. And then on the pleadings and default situation in consumer debt, the study that I'm familiar with looks at the defaults, and it's kind of an amazing thing. 80 judges' dockets were looked at, and during the period of the study, not one judge held the plaintiff creditors accountable to the requirement prior to issuing a default. And so one thing, but there was a reduction to some extent in the execution of those default judgments at the next level of process. So the study concludes, well, maybe it had some effect, but it raises a question about maybe there's a reform, and this is another measure in our index, at the front end, because we have to think about what are the incentives for judges. And as you say, they're very busy, and the other side shows up and one side does. So one thought, and this is something I think being developed in California, but in other states too, is a pleadings requirement at the front end, where if ownership of the debt isn't established, well, then the case should never make it past the clerk's office and onto the docket. That's what the policy would be. And that's a very powerful idea. Another way that, and saves time for the judges, it just reduces the number of cases on the docket, which is a blessing better than the anxious awarding of a default judgment when you know that maybe it's not deserved. And what some people are trying to do in California is test even an automated version of that, which tells the litigant when they file the lawsuit that these are the requirements, and if you can't satisfy them and submit the papers, your claim will be dismissed administratively and you can refile. So anyway, I'll take a breath because I'm talking too much, but I thought those aspects of this were very interesting.
Thank you, Justice Bright and David, for the ways that you've suggested closing some of those gaps between policy and practice, which is really important because it affects the realities for real people, clients from our low-income communities facing issues with housing, safety, debt, food, healthcare, as you mentioned, David. And when policies fall short in practice, it's really legal aid providers and the individuals they serve who feel that strain. So my next question has to do with legal aid resources. And Debbie, I'd love to start with you. The stats that we've heard today about the civil legal need in Connecticut are quite stark. So the 72% of low-income residents experiencing a civil legal need, almost 400,000 potential clients with just over 100 attorneys to support them. And I imagine that gap will only continue to grow with shrinking social services, unless we really work proactively together to expand the reach of legal aid resources. So how should Connecticut prioritize those resources, and what are some creative approaches that are already being deployed to help stretch that limited attorney capacity?
Sure. Erica, could you put up slide 8, please? Thanks. The question, no surprise, this always comes back to the lack of resources, right? I mean, we've all talked about that. Even if every eligible client could get connected to a legal aid agency, we just wouldn't have the resources to actually provide services to them. And I think just one of the really staggering stats on this slide, sorry, are the number of individuals with a disability. And that's, almost 6,000. I mean, if you look at it, you just sort of think like, what are people dealing with in just their daily lives? And then we have the crisis that I talked about before. So we look for ways to leverage what we do. For example, we were instrumental in getting fair rent legislation passed this past legislative session. And we now have the first two appeals of fair rent decisions coming up in 2026. So we're shaping policy around rent increases, and that will have wide-ranging effects, helping more than just the individual client. The NEMT case that I mentioned earlier is another example of how systemic advocacy helps change the landscape for the low-income community. And for the 3 full-service programs, one of the ways that we handle and sort of triage, I think of us as triage, going back to Justice Bright's hospital situation, it's like we're the triage for the emergency room. We have priorities that guide case acceptance in each substantive law area in which we practice. So we try to take the cases where the need is greatest, where having a lawyer makes a difference, and where alternative legal help isn't available. So this means that in family law, we prioritize cases involving domestic violence. In housing, it's eviction and loss of rent subsidies, because these days without a rent subsidy, housing is just unaffordable for our client population. In the benefits world, it's SSI cases or food stamps, which are now called SNAP benefits, and access to medical care. Each area in which we practice has its own set of priorities. We also use pro bono partners. There's been some talk about that, individuals and firms when we can. The caveat with pro bono efforts, I want to be careful when I say this because we really do appreciate pro bono efforts. The caveat is that we find that we spend a fair amount of time training an individual attorney to take some area of law, and then that attorney takes one case and, for very legitimate reasons, either can't fit anymore or decides that they don't want to take anymore. It isn't what they expected. And while we appreciate the intent, it isn't necessarily a particularly efficient use of legal aid resources unless the newly trained attorneys commit to taking a certain number of cases. But what works really well is when individuals or firms take on a project with us. So we provide training, we provide backup support, and then the law firm eventually owns the project. And I talked about that with the McCarter and English Pardons Project. And also similarly, Finn Dixon and Hurling and Robinson and Cole, as well as others, have had various projects with legal aid where eventually they own the cases. And we also have some wonderful long-term volunteers, people who have been with us for over 20 years, private attorneys who have retired from private practice, or even several who have retired from full-time legal aid work. So the joke here is that no one ever really leaves. Everyone comes back in some form or another. And all of these volunteers make a huge difference. Could we go back to slide 1, please, now, Erica, that one that shows that one. Thank you. So we can see the very helpful resources in the top row of this chart, all of which expand the number of clients we can help and which we've talked about already. And then some of the other things that we've done in the past, we've had specific grants to have mobile outreach units where we can actually get into places that don't have public transportation. And we continue to do Know Your Rights outreaches around the state to reach as many people as we can. And we have the ctlawhelp.org website, which has pamphlets that are designed for our clients in pretty much every area of practice and that we do. And then looking ahead, we're exploring AI, which is here to stay, and looking at ethical ways to use it. Possibilities include using AI in initial intakes, for example, or perhaps initial research. And we all know there are a lot of caveats around that, so we're treading carefully. And I think it might have been Justice Bright who mentioned this, it would be helpful if the various entities that run pro bono outlets coordinated efforts. So there'd be a more efficient experience for the volunteer attorneys. And then finally, also probably no surprise, we need more unrestricted funding so that we can respond to the emerging client needs. Many of our funders want to fund a specific project or a need, and we appreciate that, and we find it very helpful and necessary. And at the same time, it means that a great percentage of our funding is restricted either by use or time frame for using it. And that gives us less flexibility to meet the emerging needs of our clients and our programs. So I'm not quite sure how we get there, but that is huge for us. Thanks.
And Song, if I may, just from the Connecticut Bar Foundation's perspective, regarding the idea of demand outpacing capacity, obviously we're the primary funder of the legal aid system in Connecticut. So we think about this issue a lot. And I say we're the primary funder, but we also consider ourselves to be true partners and collaborators with our grantees. So we're not just, giving them money and, reviewing applications and reports. We're constantly having conversations and talking about what is happening on the ground, what is their day-to-day experience in working with their clients, what are the challenges that they're facing, because we really need to understand that so that we can figure out what are some innovative ways that we can try to help correct this problem, right? And we try to leverage our national partnerships. We are embedded with IOLTA organizations across the country, bar foundations across the country, and really trying to understand what other jurisdictions are experiencing, which is very similar issues to what we're experiencing here in Connecticut, and how are they addressing them. And Debbie brought up the issue of AI, and I know this can be a hot button topic for certain people, but I think we can all agree that after all these years of trying to attack this problem, that just finding more dollars and trying to hire more people isn't necessarily going to solve this problem of access to justice. And there are already ways in which other jurisdictions are using AI successfully to significantly decrease the access to justice gap. New York is already using certain tools that they've created for AI around housing issues, for conditions issues, for getting their clients getting their security deposits back. In Maryland, their main legal aid organization created an AI tool to help their housing attorneys review pages and pages of rent ledgers that would take them days sometimes and just minutes to help them be able to move their cases forward. They've also created a tool for creating appellate briefs that has literally been like adding 1 to 2 full-time attorneys to their appellate division for Maryland Legal Aid. So, from the foundation's perspective, it's really understanding like what's happening across the country, and then coming back here to Connecticut and talking with our providers and understanding like what is it they really feel is the most helpful and useful for us here in Connecticut, because obviously every jurisdiction is different. But I mean, these are, I think, the tools, and we're in the time when we have more options now than ever to really address this issue of demand outpacing capacity. And, there are some who would argue that AI is sort of like the great equalizer for access to justice. And it's the first time we actually have a tool that can really help us over this hump. So, I mean, obviously we still have a lot of work to do, but I think there's a lot of opportunity for us to explore in these different issues and really help to move us forward.
Yeah, and if I can just add to that, I think the relationship between the legal aid programs and the Bar Foundation is phenomenal and really crucial. And in fact, it was the CBF that brought to our attention an opportunity to be in an AI cohort and then funded the application fee for it. So I think, I think together we'll figure it out.
I was just going to add that I think we're in this speaker series, we're going to have separate sessions on a number of these topics. So I think looking at what other states do, AI, I'm sure will have a session on that because every speaker series, I think it's mandated, must have a session on AI. So we'll do that. But I think the looking at what other states do with justice workers and non-lawyers who are able to go into court and actually help litigants in some of these areas is important to look at. Alternative pathways to admission to the bar, which which a lot of states are using to address either legal deserts or the access to justice gap, is a topic that's worth talking about. I think that whether we decide to pursue any of those or not, we ought to be open to talking about all of those things because there's no one solution that will solve the problem here. You cannot get enough pro bono lawyers to fill the justice gap. You cannot have a large enough right to counsel program to fill the access to the justice gap. So, and you are going to have self-represented people in court regardless. So we have to figure out how all of that works.
I could add one point if I know we have other topics to get to. I just want to say about pro bono that, this panel today has focused very much on systemic solutions as it should. But, Debbie's earlier anecdotes about experiences, I just want to say that people who do pro bono have life-changing experiences themselves. Some people report it's the most satisfying thing they've done in their professional career. So I don't want to overclaim or underclaim for it. It's really a work in progress, and I definitely have my critique of things that are hard about it. But I don't want to miss that point, that if you do take a pro bono matter, you may change someone else's life and you may change your own.
I tell new lawyers that all the time. So.
Thank you. And David, that's actually a perfect segue into the next question. So now turning to this topic of pro bono, Debbie, Angela, David, Justice Bright, you've all mentioned pro bono. And I know that in Connecticut, we have some incredible, passionate, dedicated pro bono attorneys, firms. And so I'd love to hear, from your vantage point, Angela. One of the recommendations, I think, in the civil legal needs assessment was to strengthen pro bono engagement. So what are some models of pro bono that you've seen that work well, and how can we expand on those programs? And I know that we've already spoken a little bit about this, but is there anything else that we should keep in mind as we talk about pro bono expansion in the future?
Yeah, so I think, and Debbie just mentioned this in her most recent response that, I think the pro bono programs that work the best are the ones that are rooted in a structured system and equips the volunteer attorneys with the training, guidance, and ongoing support that they really need to be effective, right? So I think a really great model is one of our grantees, Lawyers for Children America, whose entire model is based on leveraging pro bono relationships to do the actual legal work. So they cultivate partnerships with law firms across the state, and they provide really comprehensive training. But they also offer continuous staff support to the pro bono attorneys throughout the life of the case, even going to court with them, second chairing in certain instances. And they're able to leverage millions and millions of dollars in legal services annually and ensure that hundreds of children who are abused, neglected, or abandoned are getting access to legal services that are very specialized. And I think, a testament to how well this system works is going back to what David said, is that if you speak to any volunteer attorney through Lawyers for Children in America, they will tell you that this is the best thing that they've ever done in their life, and it has changed their life. And they talk about the kids they've represented like they're a member of their family and they're still connected with them years and years later. And they also have said that they wouldn't be participating as a pro bono attorney without the support and structure that Lawyers for Children America provides for them. Another sort of example, programmatic example of this structured model that works is a partnership with the Connecticut Coalition Against Domestic Violence and Robinson and Cole for their restraining order project. And this has been going on for many years now, and it's also been very successful. And again, it's a very structured project where actually one of Debbie's staff members, who Lorraine Karkova, who is an expert in these matters, does the training for Connecticut Coalition Against Domestic Violence for the attorneys at Robinson and Cole who want to participate in the program. And they have a leader within Robinson and Cole itself who oversees the program once the training is done. And then when that leader is ready to step away from the program, they identify someone already within the program to step into that role and make sure that it keeps going. So again, it's very structured with a lot of back end support from the attorneys who do the training and making sure that the volunteer attorneys have the support that they need. And I know that Jamie Bell, the executive director for Greater Hartford Legal Aid, posted a comment, which another example of this is when firms provide pro bono support in the larger systemic litigation, the class action cases where they'll work with the legal aid organizations pro bono to help facilitate those very large class action cases that can go on for years and years and years, and the legal aid organization would never have the resources to be able to maintain that. But they're such an important, critical part of ensuring access to justice in our state, because we can't just continue to get change by putting our thumb in the dike reactively. We have to work systemically from the other end at the same time. So, just taken all together, I think what these models demonstrate, the lesson is that pro bono thrives when it's inside a coordinated, well-supported system. It has to have structure, training, and sustained guidance for the volunteer attorneys to provide those high-quality services. So the need is being met, the attorneys are able to provide the service and get, from out of it what they're hoping to get out of it as a volunteer.
Thank you, Angela. And I feel like, Debbie, you've mentioned a few models of how some partnerships have been successful in the past. And thank you, Jamie, also for chiming in about what's worked well with the Greater Hartford Legal Aid as well. So I'm not seeing any questions from the audience, so I will go ahead and ask my final question. So what's, been coming through in this conversation so far is not just the complexity of the challenges that we face, but also the energy and creativity driving the work to close the civil access to justice gap. And there's a real sense of momentum, I think, both in Connecticut and nationally, that gives us a lot to be excited about. So for our final question, I'd love to build on that energy and ask each of you, looking ahead, which emerging trend excites you most or gives you the most optimism about closing the access to justice gap, and why? And David, with your broad vantage point across the country, could we start with you?
So I'm happy to speak first. I feel like you're never supposed to divert from the premise of the question about the new and latest and best, but I do want to make a statement in support of civil legal aid. It is the backbone of the system. The fact that it's not the latest, newest, shiniest pebble, or maybe it is a very shiny pebble in Connecticut, I don't know, but it's just enormously important that there be continuing support for that function and also for the right to counsel in Connecticut. Having said that, I think I'm one of the unusual people that has a foot in the lawyers absolutely, but also non-lawyers tech, and that we can have that conversation and can try to figure out what's best where and when. There's this idea, not everybody embraces it, I guess, but of having lawyers practice at the top of their license, meaning that you save the lawyers to do the work that only lawyers can do. Now, some of the work lawyers do is screen things and figure out, do we need a lawyer or could somebody else do this? So, we should footnote that. But there is a movement in this country right now. I think 20 states have active initiatives around what's called sometimes justice workers or sometimes allied legal professionals. And it is a kind of wave of the moment that we haven't touched much on. I think I mentioned it just in passing, in which the idea is that if people are trained and they do a similar thing over and over, they become very, very good at it. More than, every lawyer knows that when you're a first-year law student, your whole family comes to you and says, how do I solve this legal problem? And you say, I have no idea. I'm not a lawyer yet. It's not and once you graduate, you say the same thing. You just say, it's not my practice area. I don't know. And so to have people who are very specialized in, protective orders, certain kinds of benefits, even in housing court, certain kinds of proceedings, is something where I think there's a lot of promise. And just like, I shouldn't say just like, but somewhat relatedly with AI, where I think there's also a great deal of promise, there are concerns, about how much should there be attorney supervision, how much should there be a protocol that diverts the person from the justice worker to an attorney. Are these roles for people who make money when they handle more cases, and are there financial pressures? Are they in court or out of court? All those factors need to be sorted out. But one way that people are starting to do this, I realize minutes are few, I'll just say, is to authorize an experimental model where particular programs, legal aid programs, or even outside of legal aid, can develop what they want to do with justice workers and then pitch that to the judiciary for, at least initially, a one-by-one authorization to try it, have it evaluated, and if it works, then consider incorporating it over time. And, that is an approach some states are looking seriously at.
So, I would say that I agree with the justice worker model. It's very interesting to me. It's relatively new and it's exciting. I think the other thing that we talked about at the beginning of this is the focus more on the preventative process and how do we deal with this from a holistic standpoint of what are all the clients' issues that are causing them to have to go to court, and how do we kind of take them off the table, and whether that's with diversion programs, whether that's with early intervention and multidisciplinary teams, and whether you're embedding social workers in legal aid organizations or in other organizations. I think those types of things to me are really exciting, because it is frustrating at times to be the judge in court and realizing that you're there and there's not a lot you can do for, as I keep referring to, the patient at that point. Whereas if you had been able to intervene much earlier in the process, the outcome would have been very different. So I'm not exactly sure how we as a court system fit into that, but certainly from an Access to Justice Commission standpoint, it's something that I want us to spend more time looking at.
And I would just add, from my perspective, as you probably could tell from my earlier comments, I mean, for me, it's definitely how we can incorporate AI. I feel that this is really the first tool with the potential to scale legal help at the level that the justice gap demands. And I think it represents an opportunity for where I sit in philanthropy for us to ensure that there are tools that are being built responsibly, equitably, and with true partnership with the legal aid providers and the communities that are being served. So I already said my piece earlier, so I won't go too much more in depth into that, because I did see there was a couple of questions that popped up, but that's what I'm most excited about, in addition to all the things that both David and Justice Wright already alluded to.
I see a questions directed to me about language access and evaluation, and I don't have that at my fingertips. Really, the National Center for State Courts has done a lot of work lately. And so if I'll look into that. If somebody wants to email me directly, you can find my email address. It's just dudell@fordham.edu or through the Connecticut courts, and I'll follow up with you, Giovanna Shea. I did want to say on the scalability thing, justice workers is a potentially scalable model. Like, one vision is that people who hold social worker positions or caseworker positions are or a reverend who's brought a lawsuit on this issue in the South Bronx in New York. It's a longer story I won't get into, but there are lots of people out there who just by inclination want to help people with their legal problems. Just as there are lawyers who want to help people with their social worker problems. And so enlisting people who already have paid jobs in authorizing them to give basic advice that will help people not default is, I think, a frontier area that is pretty scalable and potentially, a useful supplement to the bar. The other thing I wanted to inject is it's useful to think in terms of upstream and downstream. And Justice Bright is really talking about upstream when you're talking about solving or addressing people's social services needs in a way that prevents disputes from becoming legal problems. We see this in the criminal system too, trying to address the mental health problems before they become violations of law. But there's also a way to think about it, which I think is helpful now, because we're looking at a moment when SNAP benefits are probably going to be drastically cut, medical coverage cut, wage earners are losing jobs and being deported. And there is this issue of how do we meet the moment? There's a threat to the Legal Services Corporation's funds. We don't know how that will play out. And so trying to think of ways to enable the legal aid bar to empower it with state support, financial support, but also and philanthropic support, but also what are the upstream mechanisms like pleading requirements or like diversion programs that help people, or automation of pleading requirements is a good one, that help knock out, or statutes of limitations, nothing more mundane. But if the statute of limitations is a little shorter, it removes a whole segment of cases that would otherwise flood into the courts and need legal representation. And interestingly, when we put together our Consumer Debt Litigation Index, we spoke to representatives of the bulk credit buying industry. And one thing they said that really stayed in my brain was, we actually wouldn't mind a shorter, tighter statute of limitations. You might think we would, but if there were uniformity across states, it would make it attractive. And so it's something to think about when you're talking with the powerful interests and you're thinking about what makes proceedings fair in your courts.
Thank you. Debbie, is there anything that you wanted to add?
I think I'm good. Thank you.
Okay. Well, you've all previewed a lot of big issues, alternative models of service delivery and justice workers, preventative justice and early interventions, AI and technology, and so much more. And Justice Bright, you alluded to this earlier, but many of these topics will actually have its own dedicated session later in the series where we can take a deeper dive. So at this moment, I just wanted to thank all of you, thank of our panelists for being so generous with your time and expertise and sharing your important perspectives. I want to thank Chief Justice Mullins and Judge Thomas for their powerful remarks, and for each of you in the audience for joining us in this conversation. In Connecticut, I think we're just really wildly privileged to have such incredible leadership committed to investing in addressing the access to justice crisis in the state. But today's presentation kicks off a series that we'll be hosting throughout the year to better understand and have continuing conversations about Connecticut's civil access to justice gap and possible solutions. So we hope that you'll all join us again in January, where we will be turning to the impact of federal funding cuts. And Judge Thomas, I saw that you hopped on. Was there anything that you wanted to say? I can give you the last word.
No, not at all. Thank you for closing it.
Okay. Okay. Well, that said then, thank you all for being here and for all of your commitment to access to justice. I hope you all have a great evening ahead. Thank you and see you all soon.
Thanks. Bye.
Thank you.
Thank you.